Now we come to the doctrine of holding out. So now we go to doctrine of holding out. Section 28 of the Act deals with it. So here the section says anyone who by word spoken or written or by conduct represents himself or knowingly permits himself to be represented to be a partner in a firm, he is liable as a partner in that firm to anyone who has, on the faith of any such representation, given credit to the firm, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving credit. So here, the various elements of holding out are coming out in this particular section, which we will discuss. The first thing is there has to be a representation by word spoken or written or by conduct. So the person himself must be representing to be so, or knowingly permits himself to be so represented. Then what is he representing himself to be? A partner of the firm. And such person is liable as a partner in that firm to anyone who has. So if such representation by himself or if permitted by him by someone else as a partner, and based on this representation someone else does something, so for that given credit to the firm, etc., then the partner will be liable for the credit given to the firm based on such representation. And it is immaterial whether the person representing himself or represented to be a party does or does not know that the representation has reached the person so giving credit. So it's not necessary that I should know that I have whether my representing to be a partner has reached him or not. If that is immaterial. Then holding out, where after a partner's death, the business is continued in the old firm's name, the continued use of that name or of the deceased partner's name as a part thereof shall not itself make his legal representative or his estate liable for any act of the firm done after his death. So where there is a partner, say X and Y, and X dies, and the name of X and Y continues to be there in the firm, and by having that, if they are doing the business, then for whatever is done after the death, the estate of Y will not be liable for it, because death is a notice by itself and no specific notice is required in case of death. So who are the persons who can be liable? So he says anyone who represents himself or knowingly permits himself to be representing to be a partner in the firm. So here it could be persons who are not partners also, or it could be persons who have moved out of the partnership. So in case of persons who are not partners, it could be employees, it could be agents, etc. Then persons who have moved out, it could be retired partners, it could be expelled partners, or it could be minors who could choose that I don't want to be a partner. So these persons are liable, can be held liable for holding out. And what are the prerequisites for holding out? First, the representation as partner by word spoken, written, or by conduct. So here it could be representation by the person himself or someone else. So that both these representations will be treated as representations for the purpose of holding out. Then third party having knowledge of the representation and acting based on it. If the third party is aware based on this knowledge that he is a partner or he is acting on behalf of the firm, he makes something, then the partner and the firm will be liable. So there will not be any liability for holding out in case of deceased partner, insolvent partner, and a dormant partner. So examples we can see through certain cases. So representation as partner by words, spoken, written, or by conduct. So here, first of the instances will be allowing use of person's name in the firm name. In a case of Bevan versus National Bank, MW was the manager of B's business and the business was carried on as if it was MW and Co. So MW was actively involved in bills, documents, checks. So he was acting as if he was a partner in the firm. So here MW was also held to be liable and B was also held to be liable because the name of the firm and the name of the manager who is active is there, though he is not a partner. Then here, but he was merely a manager. The second case is of Kirkwood versus Cheetham and Smith. So Cheetham, a butter dealer, engaged Smith as a servant to manage business under the name Smith and Company. So the supplier held that both Cheetham and Smith were liable because Smith was holding himself out as an agent and Cheetham was holding himself out as a principal. Then second, giving an impression that the person is a partner. So for this, the example is case of Bass Brewers versus Appleby. So here generally in insolvency processes, you have an insolvency professional who is generally a chartered accountant, company secretary, advocate, etc. So here in this firm, a chartered accountant was engaged as an insolvency professional. And whenever you are selling any, disposing of any property as a process of insolvency, you are getting money, and that money is received in the form of a check. And the check, though it is given in the firm's name, it was being received by the chartered accountant. So he received money representing sales proceeds of mortgage property, and he did not account for this amount, and he became insolvent. So in this case, it was held that the partners to the agreement were liable, as they allowed the chartered accountant who was not a partner to be holding out as a partner of the law firm. So here, the person is not acting like a partner, but the persons are permitting, the other partners are permitting him to be acting like an agent or acting like a partner. So in which case, the principle of holding out will apply. Then the third instance is knowingly representing or allowing to be represented as a partner. So in this, for this, you have a case of Tower Cabinet Company versus Ingram. So here C and I carried on first furniture business. I retired and C continued. And the supply of furniture was happening there even after I retired and the payment was not made. So subsequently, when they saw the paper, they found that I's name is also there. So they filed a case against I and sued him and wanted the money to be recovered. So here, the court held that the note paper used was for placing the order in C had I's name and without I's knowledge and it was without I's knowledge or authority, because of which, and he was not representing himself to be a partner. So he cannot be held liable for holding out. So it was held that I, who retired from the partnership, was not liable. The only thing that could have been done is he should have destroyed the papers having his name. Then the second thing is a case where someone acquiesces in being named as a partner. So in Martin versus Gray, A introduced B to C as a partner while he was not a partner, and B did not object for being introduced as a partner. Then the relationship happened, and subsequently, when the liability was supposed to be there, B was held liable for holding out, and the firm was also held liable for holding out. Then third party having knowledge of representation or acting on it. It's necessary that the third party should be acting on the basis of the representation and after having knowledge of the representation. Only then there should be a belief in the representation. He should have knowledge of the representation, and based on that, he should have acted and given credit to the firm. If these requirements are there, then he will be there will be a liability towards the third party, and the firm and the partner will be held liable. So if the third party would anyhow deal with the firm, then it cannot be held liable for holding out. So if the dealing would have happened irrespective of whether he knows of the representation or not, or it's in the normal course of business, then you cannot say that the partner or the firm is liable. And as I told you, it is not material whether the person representing or being represented knows or does not know that the representation has reached the party. So irrespective of whether it has reached, I didn't know that he would know about it, that kind of an argument will not be sufficed. So it will not cut ice. Have you represented yourself or permitted yourself to be representing to be a partner or not? If the answer of it is yes, then whether it has reached him, I didn't know about it, these will not apply. And based on this representation and knowledge and belief in it, that if the third party acts and gives credit to the firm, then the principle of holding out will be applicable. So a retired partner can be liable if public notice is not given. So that's the reason why in case of retired partners, expelled partners, and what is it, in these two cases, it is the retired partner or the expelled partner or the partners of the firm. Anyone can go and give a notice. So the retired partner will give a notice if he doesn't want to be held liable for the purpose of holding out. The existing partners who are there will give a public notice saying that this person is no more a partner, according to section 2072, in which case they, what is it, if they don't give that notice, then they will be liable for, on the basis of operation of estoppel. So from that point of view, holding out will be applicable for the person going out, and estoppel will be applicable for the continuing partners, because they are acquiescing on the fact that this fellow is a partner, and if someone acts on it, then their liability of the firm will not be escaped. In these cases where the person is going out, for him not to be held liable, in his own interest, he has to give a public notice according to section 72, after which only he will not be liable for holding out. Then what are the instances where public notice is not required? One, in the event of death. Estate of the deceased is not liable from the date of the death of the partner, even if the surviving partners continue. So death is a notice by itself. In case of insolvency, which is civil death, the liability will be terminated immediately, and the estate of the insolvent will not be liable from the date of the order of insolvency. Then, in case of a dormant or sleeping partner, the existence of the partner in the firm is not reflected in the conduct of the business, then liability will be only for acting apparent and ostensible partner. So a dormant or sleeping partner cannot be held responsible for being liable for holding out, because the world does not know that he is a partner. So acting in relation to him does not bind him, does not bind the firm. So that is as far as the aspect relating to holding out is concerned.